Thank you, Madam Chief Justice.
Good morning.
Good morning.
Isaac Ruta is my name, Vice Chair.
Thank you, Honorable Commissioner.
Good morning, Council. Jacqueline Ngutia, Commissioner. Welcome.
Thank you, Honorable Commissioner.
Good afternoon. It's afternoon.
Good afternoon.
My name is Caroline Zilani, Commissioner. Karibu.
Good afternoon, Commissioner.
Good afternoon.
Good afternoon.
My name is Charity Kisotu, Commissioner. Welcome.
Thank you.
Good afternoon.
Good afternoon.
Omwanza Ombati, karibu.
Thank you, Commissioner.
Good afternoon, Jokindumo.
Good afternoon, Your Excellency. Thank you.
Good afternoon, Council.
Good afternoon, Your Excellency.
Anthony Mrima, karibu.
Thank you.
Good afternoon.
Good afternoon, Your Excellency.
Fatuma Sichale, karibu sana.
Thank you.
Good afternoon, Amolwande Evelyn. You are welcome.
Thank you, Your Honor.
Thank you, Honorable Commissioners, for that introduction. Mr. Omwega, because I don't think I'll be able to pronounce
Omwega without any, Your Excellency. Omwega.
Yeah, Omwega.
Yes, Your Excellency.
If you could start by telling us your county and your ethnicity.
My county is Kisii. My ethnicity is Kisii.
Very well. We'll now start the interview, which is in a form of a conversation with you, because we want to know you. And so you start by telling us the vision you have for the High Court. And within that vision,
yes,
you tell us how you qualify in terms of experience, in terms of knowledge and expertise, how you fit in that bill of a judge of the High Court. Also remember to tell us the values that that make you Mr. Zachary.
Thank you, Your Excellency.
You have 5 minutes.
Yeah, the vision I have for the High Court is to promote access to justice, independence, fairness, and enhance trust in the administration of justice. The qualification I have, Your Excellency, I have had over 25 years of courtroom experience, prosecuting daily. I have also had the experience of leadership from wherever I've come from. I started being in charge of ODPP, the Office of the Attorney General, where I was the team leader and the youngest. I was able to be there for almost 8 years. I have also worked in several places where I have managed to lead teams, including my colleagues, and being head of station. I have managed to also know how to manage people. I have managed to even learn on how to mentor colleagues, those who are just recruited. The time I remember is the year 2014, when one morning, when I was the head of the Eldoret, I received a total of 12 counsels, young, who had just been recruited. And shortly after that, the police had withdrawn their prosecution services. So it became incumbent upon me to start training them, giving them tactics on how to present evidence and how to produce exhibits. In terms of the values I have the courage, I have the independence. That can be demonstrated in all the stations where I've worked. I am also innovative. When I worked in Eldoret, I realized several sexual offences cases, we were receiving requests that the witnesses could not be traced, and because the allegation was they are relocated. After some time, I realized that we are receiving these and we are getting difficulties in prosecuting. Then I started now checking on the statement, and I got the numbers. When I called one time, I found a witness who said he had never been bonded. And the file I realized, they had bonds which had been signed. Immediately after that, I held a meeting with my colleagues very fast, and we had to change the strategy. And the strategy we changed was, we now have to to receive the files 3 days before the hearing, and check the numbers and call the witnesses, so that we don't rely on the information we get. Because I found a large number of cases where we were receiving requests of withdrawal because the witness could not be traced. When I was also transferred to Narok, I realized we had a high number of sexual and gender-based violences being withdrawn on the same reason. When I did my analysis, I realized that some of those cases were cases involving children. Immediately after that, I held a meeting with my colleagues. Subsequently, at a meeting with the Children Department, where we agreed that from now henceforth, immediately we have a case involving children, we should involve the Children Department so that they open a file of a child in need of care and protection, and they are able to place them in a safe place so that we may obtain them when we want to call them as witnesses. We also sold the idea to the Chief Magistrate then, Madam Guruprata Chuma, who put it immediately, and we agreed that without compromising the right of the accused person to be given sufficient time to prepare for the defense, we would supply them statements immediately, and shortly after that, we would take a hearing date within a week or 2 weeks, depending on the agreement from the defense counsel, so that we are able to take the evidence of the child. With that initiative, we were able to fight several cases of sexual and gender-based violence. I also believe in fairness. Actually, my decision to judge all the things we have worked is based on evidence and the law. That has also made me to run into problems, but I have been able to reflect on it and maintain following the law in making the decision to judge. So are some of the qualities I have. Also, I may indicate that immediately I was sent to Embu. I had just worked in Nairobi for 1 year. When I realized I went to Embu, I realized I was supposed to handle both civil and criminal. That time I was working at the Attorney General. I adapted very fast, and I was able to start handling those matters. I started also applying for setting aside several of the judgment, because when I arrived there, I found, since we didn't have an officer for civil department, several matters were going unrepresented. They could only file a defense, and they would be able to come. So, and the lawyers could easily go to court and convince the court that enter judgment as break. So I started applying to set them aside, because when we file a defense, the matter should go to expert hearing.
Thank you very much. Commissioner Nancy.
Thank you, Chief Justice. Council, I have a few issues I want us to discuss.
Yes.
I understand your area of expertise is basically criminal. It's mostly criminal law.
It's mostly criminal law.
So I'd ask you maybe 1 or 2 questions on criminal law and another one outside. Now, I don't know whether you've read the case of Ahmad Abdufadi versus the Republic.
I have read that one.
You've read that?
The one of the Supreme Court.
Yes.
Yes.
What was the issue in that case?
The first issue on that case, it was the admissibility of an admission they had made.
Yes.
And they were holding the view that admission was not a conviction, and it was not admissible.
So what is the difference between an admission and a confession?
A conviction must be done according to the rules and Section 25A and the rules of out-of-court conviction. This particular admission was the basis of, was in relation to the facts within their knowledge. And Section 111 provided an admission beyond a statement made by an accused person or a fact within his knowledge is admissible.
Okay.
So not a conviction.
So how does the court then treat that in terms of weight?
If in that one, if the court is convinced, it can convict on that. If it is,
If it's convinced that about an admission.
About that admission.
Yes.
Because I am aware of the case Douglas Chingok, which was a precursor. It was in the High Court. I happened to have been in the station when it was handled. So long as that evidence can be convincing to the court, or the court can look for corroboration But the most important issue is that evidence can lead to a conviction if the court is convinced. If it's not convinced, it must look for corroboration.
Okay, thank you. Now I want to take you to another area in the law of contract.
Yes.
What is your understanding about the doctrine of frustration?
The doctrine of frustration is when parties agree. One part side not to perform is part of the contract, deliberately, and therefore you frustrated the contract. And when you frustrate the contract, then the other party is compelled to go and seek remedies.
Is it the party chooses not to, or there is a supervening event of impossibility?
There is a time when there is a supervening event of impossibility.
Yes.
But there are also some times when parties can frustrate. May try to frustrate and refuse to perform.
Yes.
Yeah.
Now, would an incident such as COVID-19 be a basis to frustrate a contract?
COVID-19, when it came, it could be a basis to frustrate a contract.
Yes.
Because at that particular time, all of us were worried.
No, it's not about worry.
Yes. We were not
the legal test.
Yes.
Let's not get out of the legal test.
Yeah.
Because a contract is a legal document, a contractual document, isn't it?
Yes.
So, can COVID-19 be the basis upon which can it be considered as a supervening event that would frustrate a contract?
It can be considered. We had not foreseen that was going to come.
Okay.
Yes.
I don't know. Have you had occasion to read the case of Kwanza Estates versus Jomo Kenyatta?
I read it long time ago.
Yes.
I may not remember the facts.
All right. All right.
I remember the citation. It was versus Jomo Kenyatta.
Oh, okay.
Yes.
All right. Thank you, Counsel.
Yes.
All right. Thank you, CJ.
Thank you, Honorable Chief Justice. Mr. Omwega.
Yes, my lady.
One or two questions from me. You are a trial judge, and a matter has been brought before you where the plaintiff is seeking special damages. In terms of progressing this matter, tell us how you would handle a situation like that where special damages are being sought. Maybe to break it down further, what exactly will you be looking for in order to determine whether you can sustain that prayer for special damages?
You are right. First and foremost, you must look at the pleadings and see whether the plaintiff are pleaded for special damages. The second issue you must look at whether he has managed to produce evidence to prove all those special damages, including receipts, the expenses in the card. He must prove them specifically.
All right, that is correct. Then there is a foreigner who is living in this country. He is so much aggrieved by the provisions of the Law Succession Act that provides that a woman, when it comes to inheritance of a deceased husband estate, is entitled to a life interest. So this foreigner has filed a suit before your court challenging the validity of that statute. How would you handle such a case?
In that particular case, I will look at the Constitution and find out the provisions which support women to inherit property. What comes to my mind immediately, if it's issues of land, is Article 60 on principles of land, where even ladies are now supposed to inherit. And that issue will be Article 27 on right to equality. I would definitely dismiss the suit.
All right.
Because it will go against our Constitution.
What would go against our Constitution?
The issue where he does not want the woman to inherit.
Oh, okay. No, I think he was challenging the validity of that provision in the Law of Succession Act that says a woman is entitled to a life interest?
That section,
Yes, of the Law of Succession Act.
the woman, the lady is interested to a life interest.
Are you giving me an answer or are you asking me a question?
No. Sorry, that's why I wanted to understand it.
Oh, okay.
Yes.
I said a foreigner
Yes.
has come to your court
Yes.
and is challenging that provision in the Law of Succession Act
Yes.
that provides that a woman is entitled to a life interest in the property of a deceased husband.
That will be challenging the constitutionality of that provision. And I would have to look at the law in total and see, I will start by coming up with a presumption that that law is constitutional. Then I'll look at it and see whether it conforms to the Constitution and the fundamental rights. I will also check whether it also conforms to our international obligation, because now the treaties and principles are part of our law.
Fair enough. So we will look into that to determining whether what he's saying, what he's asserting is correct or not.
Yes.
The other question is, can a foreigner challenge the validity of a statute? Remember, he's not a citizen, he's a foreigner.
A foreigner.
Yeah, he's a foreigner.
There are rights which are available to all of us, including a foreigner. And there are those which are not available to foreigners, which are available to citizens. Like,
So can he or can she challenge the validity of a statute?
if I was to look at Courtt 258, I would say it can, where it talks about the Rockers stand in terms of challenging the validity of a statute.
And Article 27?
And also Article 27, because they are all persons, they must be treated equally.
Every person is equal
Is
before,
equal, including a foreigner.
including a foreigner. That's correct. Thank you.
Thank you. Alex.
Thank you, Honorable CJ, and Wakili, once again, welcome. Sitting as a High Court judge in the midst of a criminal trial, it comes to the information of the court that the accused person has developed some mental challenges. How do you go about it?
First and foremost, I will invoke Section 280 of the Criminal Procedure Code. Then I will order for an inquiry to be done in line with that particular section, referring to the hospital for assessment.
All that information is before you are convinced that
I'm convinced.
Yes, that he's mentally challenged.
Given that the provisions on mental challenges, several of them were declared unconstitutional, I will refer the matter to the DPP to make a decision. Now, whether
the court refers the matter to the DPP to make a decision.
Because if we look at the old law, when that finding used to come, we used to wait for, before those provisions were declared unconstitutional, we wait now to ask the DPP, how do you want to proceed with the matter? But currently, if that happens, I will stop and terminate the proceedings. And now work on ways how this person who is mentally challenged will be provided help.
So, as a High Court judge, faced with that situation, you will proceed to terminate the proceedings.
I'll proceed to, now that we have case law which has stated that, because I am not the only party in the matter, I would have to hear both the defense and the prosecution before I make that decision. In the process, they may gradually give in and say, the prosecutor may give in and say, Your Honor, in my road, I want to withdraw the matter. Now that there is no guilty but insane, we don't have that provision anymore.
We have not even reached that end where you find somebody guilty but insane. You are just at the midst of a trial, yes, and this information comes up.
Yes. The information has come up through the prosecutor or through the court or through a relative. That probably...
It's medical evidence that has been presented before you. Here is medical evidence. This accused person
yes,
is mentally challenged. than well?
From my experience, Your Lordship, I can say I will seek for a second opinion.
You get the second opinion confirming the first opinion?
To confirm the first opinion.
Yes, you have the second opinion, which is the same as the first opinion.
Which is the same as the first opinion.
How do you proceed as a judge? This is a question in your domain, criminal practice, isn't it?
Yes, it's a question in my domain, criminal practice, and it's a question which has been unresolved because several provisions in that criminal procedure, Section 162 to 167, several of them have been greater than constitution.
It has been resolved.
It has been resolved.
Yes, by several decisions by the High Court, it has been resolved.
Yes.
Okay, we leave it at that. Have you heard something about alternative justice system?
Yeah,
AJS.
I have heard.
You've heard about it. Okay. What is your perspective on this AJS in criminal matters?
Immediately you talk about alternative justice system mechanism. My view.
Does it apply in criminal cases?
It applies to the extent that it is not inconsistent with Article 159.3. If it does not violate the Bill of Rights, if it's not inconsistent with any written law or constitution, if it does, it's not repugnant to justice. Like now in criminal matters, because these are alternatives to trial, let me call them as alternative to trial, we have pre-bargaining and diversion. Diversion is alternative to prosecution, pre-bargain is alternative to trial. So it applies to some extent. There is also promoting of reconciliation under Section 176. It applies.
What about applicability of traditional ways of resolution of disputes?
So long as they meet the test as has been provided under Article 1, under Article 159.3, it will apply. If it doesn't meet, it will not apply.
So parties appear before you in a criminal trial. They tell you this is a murder case, but the parties have discussed at home. We've called our wazees. We have undertaken some traditional ceremonies. Everything is cleansed. We are good to go, and we have come to withdraw it.
Criminal matters are matters of public interest. And the custodian of public interest in the Constitution is the DPP. So in those cases, the matter will have to be considered by the DPP, and I will get a response from them.
The DPP says, I have no problem.
If he says, but from where I sit, that's a personal view, I have no problem with the HS, so long as it does not go create a scenario where I would decide, if you are a competitor in my constituency, I would decide to put 10 million in the account. Then after I arrange for your debt, I come and use HS and say we have agreed, and the matter is withdrawn, then I will get now a soft landing in terms of content. So if it is not against the principles I set out in Article 159.3, I will agree. If it is, I will not.
So lastly, in this scenario,
yes,
you find that everything is quite in order. Under AJS, we are still under AJS. You find that everything is in order. You've checked; it complies with the constitutional safeguards. And how will you go?
If it complies,
just a minute. How will you go forward? Will you adopt that agreement and sentence, or will you just adopt it and the matter comes to an end? You discharge. If
it is an agreement outside pre-agreement, just an agreement which is not pre-agreement. If it's an agreement pursuant to pre-agreement, I will take them through the due process of satisfying that that agreement was entered properly through the due process. Then I will now, after I'm convinced, even the views of the victim have been taken into account, the views of the higher have been taken into account.
This is not, sorry, we are talking some of the time. This is not plea bargaining. This is AGS, alternative, a matter allegedly sorted out through traditional means. It's not plea bargaining. Plea bargaining is something different.
If it satisfies the condition, I will proceed to stay the prosecution and release. and release the person
Okay.
Yes.
Thank you. I wish you the best.
and discharge the accused.
Okay.
Thank you, Chair. Good afternoon, Council.
Good afternoon, your Commissioner.
Yeah, you're known to be a brave state prosecutor. DPP.
Yes.
Is that factual?
About me.
Brave, yes.
That's what I'm told in
Okay.
every station I've worked.
And do you believe that you're a brave one?
Yeah, I do.
Okay.
I do.
Thank you.
I am only brave to the extent that I'm supported by law.
Okay.
Yeah,
Thank
and the
you.
Constitution.
Thank you. So I've gone through your sample writing. You've shared articles and submissions in matters you handled in the High Court. They do combine academic depth and practical effectiveness, the articles. So they are well grounded and reform oriented. Your writings demonstrate clear issue identification, sound application of law to facts, coherent reasoning, and disciplined use of precedents. The conclusions are clear and the tone is professional, so I must commend you for that.
Thank you, Commissioner.
So you're allowed to take your water. I forgot to ask whether you need a water break, so kindly.
Thank you, Commissioner.
There is a paper you presented, which you shared with us, a 2012 paper on the challenges of prosecution of corruption cases in Kenya, with focus on Uasin Gishu.
Yes.
And you, in your conclusion, you said that these matters don't go far because of weak laws, but because of institutional capacity constraints in the office of the DPP. Has the situation changed? If yes, how?
From during that time when I conducted that research, I was the only one prosecuting the anti-corruption cases the entire of North Rift. And as I was doing that, I had to do a research request magistrates. I received an approval from NACOST, and that time there were those challenges. We had institutional capacity in terms of manpower. We had also challenges in terms of ICT. We had also challenges in terms of funding. But it has not changed free, because at the moment we are doing disclosure of statements manually. If we had free embroidered technology, we would be able to supply the bulk of experts online. As from my experience, the cases of anti-corruption, I could do a case with almost 1,000 documents. Forgers, minutes, a lot of things, payments which have been paid in part. I could do that. So immediately we take the brief, it will take us quite some time to go and do photocopies. That has not changed as we talk today. In terms of manpower, it has changed, but it has not reached the level it's required, because now and again we keep on losing staff. But I can say we have improved drastically in terms of the factors I considered at that time.
Okay, thank you.
Yes.
My last question is Article 21, Sub-Article 1,
Yes.
requires the state and every state organ to observe, respect, and protect and fulfill fundamental freedoms in the Bill of Rights.
Yes.
What is your understanding of these obligations? Are they the same or they are different? Obligation to protect, promote, and fulfill.
The obligations are the same. We are all bound. State organs, state officers, public officer, and every person.
So what does protect mean? What does promote mean? And what does fulfill mean? Do
In
they mean
the
the same thing?
In the protection is a situation where you don't cause that violation.
Mm-hmm.
The next one was the promotion.
Promote, yes, and fulfill.
The promotion is where, when a matter goes to court, the court now should interpret the law in a way to promote. It can also be promoted by every state officer by doing things within the law.
Mm-hmm.
Yes.
Fulfill?
In fulfillment, you or every person has a right, has an obligation in terms of protecting, promoting, and fulfilling. Every person has that right. This constitution of ours is extremely transformative.
No, I just needed you to describe what
Yes.
those 3 specific issues mean?
To promote is to act in a way that you allow people enjoy.
You had already done that, so
To fulfill is to ensure that you meet those rights.
Okay, you may need to check that out, and all the best. Thank you, Chair.
Yes, I want to test you a little bit on the jurisprudence of the Supreme Court. Now, I want you to assume, I'm going to give you a scenario. So you have person A and person B. They are actually related. They are cousins. They live in the same community. For a number of years, person A has been in and out of a mental health hospital, and he has been diagnosed to be a dangerous schizophrenic by the medical professionals. But he comes in and out. There is then a general election, and persons A and persons B contest. They contest on different political party platforms. They are cleared by the IEBC, and they go and they run for the election. And in the election, Party A wins. Party B then comes before you. You are in election court, and says, this fellow, Party A, is of unsound mind, and therefore, under Article 99 of the Constitution, he is unqualified to be a member of Parliament. Strike out this election. What would your findings be, and which Supreme Court decision would guide you?
I have not interacted with the Supreme Court decision, but I can try in terms of how you proceed. The matters relating to election are matters which come to court and are challenged on the issue of non-compliance with the law. And that non-compliance with the law alone cannot make somebody nullify an election unless you further demonstrate that that non-compliance will adversely affect the results. But in this instant case, it goes to the competence of the elected person. And this, they must bring evidence to the effect that this condition is suffering from is a permanent condition. If it's a condition a person can recover, then it will be, the burden on the person who will have to prove that will be on the person who alleges.
But just let me guide you a little bit. You are an election. You are sitting as an election court,
Yes.
not as the High Court per se.
Yes.
The petitioner before you, being a member of the family, had previous knowledge of this condition, but did not raise it at any point before the election. Can he bring this ground to your court?
He can't bring that ground to the court.
Why
He will
not?
have to go to the High Court. The competence or incompetence of a party is supposed to be dealt with in the tribunal dealing with matters of election. Then it comes to the High Court. That is different. With the election, is about nullification.
Okay, so that is correct. The Supreme Court case, which I was trying to jolt your memory, which sets that principle, is Mohammed Abdi Mahamoud.
Okay.
Yes.
Thank you.
But you got the principle.
Thank you.
The second question I would like to ask you is relating to the office of the DPP.
Yes.
Can you give me two principles which limit judicial interference in the mandate of the DPP?
Two principles.
Yes, which will limit a court's interference into the mandate of the DPP.
One, if the DPP acts according to the powers conferred on him by the Constitution, and if the DPP acts in public interest and the interest of justice,
Okay. Do you recollect which matter that was in the Supreme Court in which those guidelines were laid out?
The Wafula, the Benson Wafula case.
Okay. Yeah. There was that actually, and there's also Saisi?
The Saisi one also.
And Saisi. Yes. Thank you very much.
Thank you, my lady. Good afternoon once more.
Good afternoon, Your Honor.
You work at the DPP. Do you have a performance appraisal system there?
We have a performance appraisal system, Your Honor.
Mm-hmm. How does it work?
The performance appraisal system, we get our target, the department meet and extract the targets from the ODPP strategic plan. After they extracted the targets from ODPP strategic plan, then now those departments again now will cascade them to the officers. And the officers will now discuss with the heads of department or their supervisors and come up with targets. And these targets, they have targets, and those targets must be smart. And they must align to the targets of the organization. Then every year, they are reviewed quarterly, and at the middle of the year, if there is any changes, you can make changes. If you realize you have challenges with some of the staffs who work under you, you can put them on performance improvement plan so that they can improve. You can take them for training and develop them. You can coach them. Then you proceed as you proceed on assessing them. Come to the end of the year, you will have to look whether this person met his targets. And that will go through an assessment where the person will have to come before you, you are the supervisor, with the evidence of the targets you agreed and you verify, then you award him the marks. And as you award him the marks, you will see whether he has met the standard. There are criteria which have been set. If he has not met the standard, you may also, including the media, you may also discuss the challenges and see whether the challenges are real or the required intervention of the DPP. If you find the real and the required intervention of the DPP, you will have to discuss it with the post. But if you find the challenges are personal, you will have also to think of putting them on performance management improvement. Mm-hmm. You may also warn them. For those who have performed well, you may send them a letter of recommendation. You may also give them feedback. Long time when it started, we used to get 1 month salary bonus for once your organization has performed well. But I think it's not there these days because of challenges of finances.
Okay. Now, I presume that's what you do with the team that works under you, but do you also get appraised yourself?
I also get appraised.
How was your last report?
The last report, when I checked, my supervisor indicated and awarded me 100%. Because on the areas which we had agreed in terms of reforms, legal reforms, coming up with policies, I had come with all of them. And in terms of participating in policy development, I had attended all of them. Mm-hmm. In terms of going to court, I had handled my matters. In terms of advisory, I had the supporting document of all the matters, and they were checking from the system on the matters they had allocated to me, whether I had advised them in time. They came with all of them.
Okay. Have you supplied us with that report?
I had not known whether it's required. It had not been put to my attention.
Okay. I want to ask you something else. When we're engaging with the stakeholders in preparation for this exercise, the feedback we got is that there is a lot of backlog in the High Court, and what they need is heavy lifters. At the same time, they want people who are able to hit the ground and run, a plug-and-play situation. So I want to engage you. I know your background is criminal, coming from the DPP, but I assume you, of course, have appraised yourself in other areas of the law. So I want to engage you on succession. Could you please walk us through the steps in intestate succession, the procedure in intestate succession?
Thank you, Madam Commissioner.
Mm-hmm.
First and foremost, in the procedure of intestate succession, you must obtain a letter from the chief. You must also you must also be able to get records of all the assets. If it's land, you must be able to attach document in support of your application.
Yes.
You must also get an affidavit in support. You must also get an affidavit
In support of what?
in support of the application to become a petitioner.
The petition, yes.
You must also get an application of sureties. The sureties will now say you are a fit person.
So you have the guarantee by sureties. I'm assuming you also have the petition because you've just talked about the affidavit.
Yes.
So we have 3 documents so far. Yes. What else?
After you have that, you must also have the statement of the chief. Yeah, you must also have the right of the chief identifying the beneficiaries, and of course, you must also be able to identify the creditors.
Okay, you've given us 3 documents.
Yes.
Is that all? You've talked about the guarantee by sureties.
Yes.
You've talked about the petition, affidavit in support of the petition. You've talked about the documents of title.
Yes.
You've talked about the chief's letter.
Yes.
Any other document?
Those are the ones, Your Honor, I can remember.
Okay.
And as I am appearing before you today.
Okay.
Yes, but I know so, I can check and get all that.
Okay.
Yeah.
So now, what is the next step? You have all the documents in the file. Yeah. Everything is in order. What is the next step?
The next step is to take it to court for filing. The court will go through the document. If it finds that it meets the required standard, I will be required to. They will send it to the central registry. Then I will be able to do. I should be able to pay the money required at the government printers for purpose of assessment. Upon verifying, doing a search at central registry, the same is sent to government printers, and the government printer will print. I will have about, I think, 30 days for anybody who has an objection to file after the letters have been issued. Upon that period ending, I will be required to move the court after 6 months, and if there is a pressing issue,
after 30 days, the Gazette notice has run for 30 days.
Yes.
What happens? What is the next step?
After the 30 days expire, the letters will be issued by the court. Upon the letters issued to me as an administrator, I will now look at the estate. If there are pressing needs, which will necessitate that the application for confirmation does not take 6 months, I will now move to the court and put forward, make an application why the letters of administration should be confirmed earlier than third. But ordinarily, we like the 6 months so that people get enough time, so that family members can discuss, family members can be able to obtain consent in terms of sharing, subsequently filing of the application in court for confirmation with the affidavits from all family members confirming that's how we have agreed. If they confirm that's how we have agreed, and we are supposed to appear personally before the court, upon appearing personally before the court will certify that the people who have signed the consent are the really people who are the beneficiaries, and they have agreed to the terms of the confirmed grant. Then after that, the grant will be confirmed. Then, assuming there are no debts to be paid, then we will go ahead to share to obtain the confirmed grant, proceed to the respective places upon the sharing. Then if I am the administrator, then I will be able to start doing transfer by transmission. Yes.
Is that the end?
Once we do transfer by transmission, then each and every person will get his share. Then we will end up the estate. But in a situation where there is a dispute.
Before we get there, is that the end?
When it has been confirmed and
when you have shared, when you have distributed, do you come back to court as an administrator?
Ordinarily, you are supposed to come to court as an administrator and account if you had collected some. You account or now you administer the estate. Okay.
Now, in a situation where one of the parties, you said, after waiting 6 months, they discuss, they agree on their shares, they file their affidavits and come for confirmation. In the event someone is unhappy about the mode of distribution, what is he or she required to file?
She will file an affidavit of protest.
Okay, thank you, and I wish you well. Thank you, my lady.
Thank you very much, Honorable Chair, and welcome again, Omwega.
Thank you, Commissioner.
Now, how will you balance the constitutional imperative for expeditious justice with limited judicial and administrative resources?
The way I will balance is I will have to analyze the work before me and prioritize. If there is administrative work, I will have to delegate so that I deal with the judicial work, delegate to other administrators to deal with it. I will also have to, upon assessment of the claims and going through pre-trial, I will have to persuade parties to go through ADR. So that way we will have to reduce backlog. Another one, we will have to ensure that we use technology in terms of hearing, so that we don't need to travel to other places where there's backlog. If there's backlog in Kisii, for instance, where I come from, and I am a judge in Kisumu, and probably the work in Kisii is high, I may agree, if I'm in charge of Kisii, I may request that colleagues from other places through the Chief Registrar of the Judiciary and Madam Chief Justice and the Principal Judge to allow them come and assist us. Or they can do it, because of resources, they can do it online.
Yeah, so how do you leverage with technology, and especially when you're also dealing with a public that is not that's not able to access some of these resources, technology?
I may commend the judiciary. The judiciary has come up with judiciary kiosks in all Otuma centers, where people are to assist those who are not able to use the kiosks. But if in any event I come across, if in any event I come across a litigant who's totally unable, I would have now to ask him to come so that we can do the matter fiscally. But ordinarily, the judiciary has gone a step ahead and availed that service to the public, and they have done proper sensitization. They have sensitized properly, and now people are aware if they want to file something online, they will have to go to the judiciary kiosk. And if they want assistance, they also know they will have to go and seek assistance at the judiciary kiosk, who may ask them, assist them on how to do it, or go to the next court and be shown how to do it.
Okay. Now, finally, what do you think your colleagues, how do they describe you, the colleagues, the stakeholders, or even the public?
The colleagues trust me, and they have told me as such. And when I have facilitated in Maritachians trainings like court users, I have had an opportunity to meet all the Batin court users who have told me you are doing a good job, including the last 2 stations where I worked. I have received feedback as I was leaving that you have changed the way things were done, and we are happy about you, and we wish you well. In terms of members of public, they know I am a strong believer of justice, to the extent that they know if the case does not have evidence, it will not pass at the stage of decision to charge. That reminds me, at the time I went to engineer, and I found that we had prosecutors equivalent of the court, and immediately they go to court at 9, police come later with files, and as they are in their conducting trials, they keep on signing charge sheet. I had to change that culture and insist there's no signing when an officer is in court. They should wait until the officer comes so that he can now objectively look at the file and make a decision to charge. Yes. That in the beginning appeared to be making them uncomfortable, but as I stayed there with time, they understood, and I received a feedback and said, this is what we have been waiting for. Yeah. So in this very many years of experience, is there a time that your integrity has ever been put to test? Yes. When I was working in Eldoret, I may try as much as possible to give a scenario, and I hope it will not reveal the parties. There was a case involving an institution, and the politicians had gone to close the institution because they did not want the person who was heading. And when they went to do that, it was in open, and they were seen, and even members of the public were saying, this is a person who had the chain and who was rocking the office. One evening, one afternoon as I was seated in the office, some senior officers came to me saying that we have agreed that this matter, you should recommend that the students pay for damages. I respectively did not tell them anything. I told them I've not looked at the file. Once I look at it, I will appropriately give you an appropriate advice. Immediately that sent me a red flag. I immediately looked at the file and sent it to Nairobi. Upon sending it to Nairobi with my recommendation, the then DPP agreed with me, and the politicians and their supporters were charged. So from that time, we did not discuss with these agencies because I did not tell them my answer. I did not misbehave. I controlled myself. And I told them once I look at it, I'll deal with it. At I left them, I told them this is a matter which is to be handled in Nairobi. But I had sent it to Nairobi with my recommendation. And then the DPP agreed with me. Actually, at one point, the politician had organized for a protest against me because of that decision. When they were about to do it, they were reminded that the decision was not made by Omwega. The DPP was on air then saying he has directed the given politician to be charged. That's what saved me.
Okay.
Yeah.
All right. Yeah, your colleagues agree with you. They say you are independent, you are courageous. However, there are some who think that you are contemptuous to the extent of insubordination, and that in some instances where the DPP gave directions, he viewed the directions as not merited, and you felt that the DPP could not match your intelligence, a factor that caused your transfer from the Constitutional and Human Rights Division, which you previously headed. You also said to have a bit of nepotism. What do you respond?
I'm hearing for the first time. When I was transferred from the department, I was given every responsibility. Currently, I'm the head of Lower Eastern Region, where I'm managing Embu, Meru, Tarakaniti. I'm also managing Kitui. That is an heavy responsibility. That has never been communicated to me. I will for sure tell you that the DPP personally, as in the past, commended me. So we have never had those exchanges. Those may be perceptions. Those may be, and in life you can't miss perception. You can see, like that time when I made a decision on forward to Nairobi, the perception was that I'm the one who had ordered for the arrest. But in actual sense, when it came bare to them that the decision had been made by the DPP, I was saved from a protest, including this one. The colleagues I've worked with, including the ones I've headed, I've never gotten across that. And if you were to ask the DPP recently, he has also given me more assignment as we talk, as I was away. He has also maintained me as his representative in almost all committees, notwithstanding the transfer. Those may be perceptions, but in terms of responsibility, that's an heavy responsibility. I was in charge of around 10 members of staff, councils who were doing constitutional and judicial review. I am now in charge of councils who may go to around 30. Yes. And as we talk, even last time I was with the TPP, he never saw that. That probably may be, in this scenario, you can't miss people sometimes who may talk negative about you. And I've learned to take it positive. And if I reflect on it, if it's true, I change. But that has never been brought to my attention.
Okay.
Yes.
What about nepotism?
Nepotism, I have never worked in a place where there are cases only. That I must confirm.
How do you deal with that?
Nepotism, I have never been confronted with a situation where I'm making a decision about my kinsmen.
Okay.
Not, you know, if I may give you an example, when I worked...
No, I think that's fine. You have explained yourself.
in the station I've worked, including engineer, I was the only Kisii. When I worked in Embu, I was the only Kisii. So I do not understand. But people are entitled to their opinions. Yes.
That's fine.
We are all charged, by the way, depending what you are using to charge. Yes, we are all charged.
Okay.
The bottom line is, are you complying with the law? But in terms of the transfer with my boss, that has not been communicated to me. He actually told me, because you are doing the mentorship, I'm adding you more responsibility so that you may be able to assist colleagues in those areas in terms of advice. That's the feedback I have from him.
Fair enough. You have explained that people are entitled to their opinions anyway.
Yes.
So thank you very much. I wish you all the best.
Thank you.
Thank you, Ms. Mansela.
Thank you, Honorable Chair. Now, Council, as you seek to join the judiciary as a judge of the High Court, I'm sure you've done a bit of your study on the judiciary. Would you tell us the core values of the judiciary?
The core values of the judiciary is independence, impartiality, fairness, professionalism,
Are you guessing? Are you guessing?
No, I am trying to remember.
So there are those that the judiciary identifies with,
yes.
And there are 5.
Yes.
Which ones are they?
Independence, transparency, accountability, professionalism. Those are the ones I can remember.
Okay, you will need to refresh yourselves on those ones. Now, tell us your 3 top values that you hold dear as an individual.
My 3 top values, I have a value of humility. I am able to appreciate the officers I work with who come up with ideas. I am also easily persuaded. I also believe in lifelong learning. I am also independent. I am also a person of impeccable integrity.
Okay. Yes. As you mentioned, your values, humility is one of the values of the judiciary.
Yes.
So like I said, you'll look into that.
I will look into that.
How has the use of technology impacted the work of a judge, both positively and negatively?
The positive bit is it has assisted in dealing with the issue of missing files. It has also assisted with dealing with the issue of missing breedings. It has also been assisted to assist in case tracking. You can also use it to follow the progress of the case. Negatively, save for those who may use it for judgment, which at the moment I will say it will not be proper because of the integrity of the information from where that judgment will be done, but it has been helpful even in analysis of that. But the only challenge I have is when it's used for writing judgment.
Okay. In the line of on the line of duty, what would you say has been your greatest challenge?
One of my greatest challenge is when I used to work alone in a station.
Please speak close to the mic.
When I used to be the only counsel working in a station and serving about 3 counties, then that was before the 2010 Constitution. The challenge was I used to find myself carrying work home because I would stay in court from morning to 5 and I'm required to advise. That used to be a great challenge because there was no work-life balance then. Of course, then I was young. I would be able to manage. That was one of my greatest challenge.
So now there's a lot of workload in the High Court, and you may be faced with such situations. How will you manage?
One of the things I will do, I will prioritize cases depending on the complexity. I will also check if in that station I also have work which is not judicial, I will interrogate that job. I will also ensure that I am able to take care of myself, because I will be able to assess now that I've become fairly, I'm not old, but fairly older than I was then. I will also ensure that in instances where there are matters where I am supposed to make decisions immediately, I will be able to make decisions immediately for simple applications. I will also be able to persuade councils so that they can also do away compromise applications that we move to the main one. I will also be able to use to persuade them and sensitize them on the importance of ADR.
Okay. Thank you, and I wish you well.
Thank you, Madam Commissioner.
Yes, karibu tena. Now, what is blue economy? And do you think it's important to Kenya?
Blue
economy.
Yes. Thank you, Commissioner. Blue economy, according to me, is matters relating to fisheries and maritime activities. It is extremely important to Kenya because it's part of our economy. And we have people in Kenya who have taken it as their economic activity. And it contributes to our gross domestic income.
What do you understand by fair administrative action?
Fair administrative action is when the action is lawful, reasonable, it passes the test of due process, where the reasons are given for the decision and people are given sufficient time, the principle of are given sufficient time to respond, where people are allowed to appeal, where they are allowed to be given a decision timely. This is fair trial, generally, including where they are able to move by way of judicial review, where they can refuse some of the decisions. And actually, fair administrative actions is our constitutional provision under Article 47, and it has been operationalized by a Fair Administrative Actions Act.
Why is public participation important in public administration?
If you read Article 10, it says any person, state officer, state actor, when he's interpreting the Constitution, must take into account public participation. When he's interpreting the law, he must take into account public participation. When he's coming up with the policy and implementing it, must take public participation. And public participation is one of our national values of good governance. That's why it's important.
In interpreting the law, you require public participation.
You require to see whether in interpreting the law, you need to check whether it was subjected to public participation.
That's what you would do as a judge before you interpret the law. You would do public participation.
I'm reading Article 10 the way it has been done. Okay. Actually, it's one of our national values which must be upheld in every activity we do.
All right, thank you. Have a good day.
Thank you.
Thank you very much. I think we are almost closing this interview. But before we do this, I want to take you to civil practice.
Yes, you are.
Because if you are successful, that is almost going to be 60%, 70% of the work you'll be doing in the High Court. And you tell me what you understand by the doctrine of ripeness and justiciability.
The doctrine of ripeness.
Speak to the mic.
The doctrine of ripeness, Your Excellency, is when you go through pre-trial conference and you are convinced that the matter is ripe for hearing. Or when you have exhausted all the other remedies before you come to court, then you say that matter is ripe to be heard. But then the next... Justiciability. Justiciability is when a matter can be adjudicated by a court. When the court is not precluded from adjudicating it. But that doesn't mean that that issue merits. But if it's an issue which requires court to deal with, that then we can say that issue is justiciability.
Okay, do you have any case in point to demonstrate that ripeness or justiciability where the courts have pronounced themselves in those two areas? Yeah.
I think the Communication Commission Authorities of Kenya, I think is one of the cases where they've talked about it. Where
what did they talk about?
When they talked about constitutional avoidance, when they referred the matter back to for determination by a tribunal which was provided under the Act to deal with.
That is now justiciability.
Yeah.
How about ripeness?
Ripeness, I know
I think
many,
you can
but I'm unable to remember.
You can refresh, because even the way you described it is not. It's not the doctrine of ripeness. That one you can refresh. I
can refresh on that too.
Yes.
Yeah.
Yes, I think this brings us to the end of the interview. But before we release you, we always give a candidate an opportunity also to engage with us.
Thank you, Madam Chief Justice and Commissioners. I must express my gratitude to you all for having given me an opportunity to appear before you and present myself and have this interaction. For me, this is a milestone in my career. And for that alone, I am extremely thankful. I do not have anything to add. I may only wish you well as you continue with this exercise.
Thank you very much. On behalf of the Commission, we also wish you well. You said you came from not Embu. Is it engineer?
No, I was an engineer 2 years ago. Then I have been in Nairobi for 2 years.
Now you're in Nairobi.
I've reported to Embu to be in charge of Lower Eastern.
Okay.
But I have not had time to be there. I will be going back on Monday.
Okay.
Yes, when I will be finishing my leave.
Okay.
But I have been at the ground and I have worked there before.
Okay.
Yes.
So it's a familiar territory.
It's a familiar territory. But now with expanded jurisdiction in terms of areas which I manage and the people whom I supervise.
So is it only Embu County or?
No, I supervise. I am stationed at Embu, where the regional office is, but I'm supposed to supervise my colleagues in Meru South, Meru, Embu itself, and Kitui. The way we have arranged our areas in terms of span of control, then I'm supervised in Nairobi also. I think to clear the air, for me, this is a time I have an expanded responsibility, unlike the kind of views I got that probably that was national.
You want to leave that new expanded mandate to come to the judiciary?
If you realize from my CV, I have been in the organization now for 26 years.
In DPP?
In the DPP. And if you see my vision is to promote access to justice, fairness, and constitutionalism. And participate, assist in coming up with jurisprudence. That now I will get an opportunity to write a judgment, which I've never gotten.
Very well. I wish you all the best on behalf of the commissioners. We will get in touch with you when we complete the exercise. Keep up the good job of, because even as DPP, you access justice.
Yes.
And it's a competitive, very, very competitive process, but we wish you well.
Thank you, Alex.
Yes, take our greetings to the people of Embu.
I will.
Yes.